My name is Emily Newman. I'm an attorney with Ruddy & Newman PC. Our firm practices immigration law, solely in employment-based immigration law. We've been doing so since 1997. Today we're going to be talking about all of the immigration updates, the hot topics that have been going on for the past few weeks. Specifically, we'll be talking about what's happening with the H-4 EAD, what's this new memo about denying petitions or cases without issuing an RFE, what's the new NTA memo. We'll be talking about third-party placement and STEM extensions, what's going on with the H-1B lottery cases. Lots to talk about today. Also with me is my partner, Rahul Reddy.
Hi, this is Rahul Reddy. I'm a partner in Ruddy & Newman PC. We established this firm in 1997, April 1st. That's when the new IRA rules started, 180 days and 360 days. We're going to explain that later on about how that is going to impact our start date of April 1st of 1997 is going to have some impact on the memo that is becoming effective on August 9th.
All right, so I guess let's start with one of our common questions that we're getting right now. Do we have any updates on the H-4 EAD?
None. The H-4 EADs are still active. As we have indicated before that the H-4 EADs, there is a possibility that the administration might put some restrictions or probably might not allow to have extensions done. The administration did indicate that they are going to come up with the proposed regulations possibly in June or afterwards. At this point of time, this is almost July end, we have no proposed regulations at this point of time. We may be expecting pretty soon, but at this point of time, you're allowed to file the H-4 EAD if you're eligible for. You're allowed to file for H-4 EAD extension if you're eligible for. If any of you guys are eligible, we recommend strongly that you do file. Now, when and if the administration is going to come up with the proposed regulation, it may not be the end of the world for you to file the H-4 or H-4 EAD. There is a good possibility that they will give time by the time the regulations are going to be effective. You could still file for the H-4 EAD most probably, and you could possibly do a H-4 EAD extension too. We're expecting that when the proposed regulations are going to be issued, by the time they become effective, it might take almost about 6 months. The last time when they really wanted to do the H-4 EAD, it took them 1 year after the proposed regulations were being issued. So even when the proposed regulations are going to be issued, we are expecting that you will have at least 6 months for you to react on those things. Most probably the existing H-4 EADs, we are expecting them not to be taken off. Maybe the further extensions, they might put some restrictions on it.
Yeah, and I think that, we were expecting a proposal to happen in June based on the unified agenda. That didn't happen. Not likely going to happen in July either, as the proposal has still not been submitted to the OMB for their review and approval. That has to be done before the actual proposal can be published in the Federal Register. I also want to mention that coming up later this week, an advocacy group is doing media training specifically for those interested in fighting for the H-4 EAD. So if you follow me on Twitter or you're on Twitter, follow me at immigrationgirl.com. I will get that information to you. I don't have it handy in front of you, but I just thought of that. So this group is going to be providing free media training to H-4 EAD holders as well as their employers, so you can let your employer know about this as well, as a way to help you share your story, get the word out about why this proposal is a bad idea, why we need the H-4 EAD, and how, just help us try to keep the rule in place. So stay tuned, follow me on Twitter for that, at @ImmigrationGirl.
Emily, this news that came out right now, denaturalization, those people who have had, the wordings that were being used in some of the major news media is that if in the citizenship application they answer the question that are there any crimes that you have committed and you are not been arrested for, and if the person has traveled at 60 miles per hour in a 55 miles per hour, the USCIS may denaturalize. In other words, take their naturalization, because they lied on the N400 application. What are the practicalities are there? Do they really are going to do it, or how is it going to work out?
Yeah, I think that there's And we talk a lot about the news kind of over-exaggerates things sometimes, or makes things seem worse than what they actually are. I would be very shocked if someone who said no, they hadn't committed a crime but actually sped 5 miles over the limit is going to be denaturalized. I just don't think that that is the purpose of the denaturalization process. I think they're looking for bigger fish to fry, bigger misrepresentations, things that are more material to whether we want you to be a citizen particularly. So I think in the majority of cases, it's not something that's going to happen.
Yeah, I don't think so that if you have sped 5 miles above, it should be some material misrepresentation. That's my opinion though. And in those people who have some drug offenses and they did not disclose this, and the USCIS was unable to find their investigation, now if they found that they had some drug offenses before they become naturalization, possibly they will have some impact on it. But for those all law-abiding citizens, those people who might have been 5 miles above 55 miles when there is a 55 miles, I don't think so they should be worried about as what is projected in the media. As you should always go to the source of the news though, and source of the news, and mostly when it is a legal matter, when it's an immigration matter, you should go to the immigration lawyers. And now with media expanding, with social media, you have access to going directly to the source. Like us or anybody else like us would be an easy way for you to react on that. Emily, on the issuing denials without issuing an RFE or without issuing a notice of intent to deny, that memo is going effective on September 11th, as you know, Emily. On your research, what did you find? What is a possibility that we do see quite a lot RFEs? Is it that every time when we are getting an RFE, they are now not going to issue an RFE and they're going to issue a denial without issuing an RFE? Are there any specific circumstances you think so that they are not going to issue an RFE?
Right, yeah. I think that in the memo, they're really focused on petitions or applications that are filed as a placeholder, meaning that I don't have everything with me right now to file, but I'm just going to file it and get it on file, and then I'll provide the documents later when I get a request for evidence. Those are the type of applications I think USCIS is trying to avoid people filing by issuing a straight denial. So that would be a situation where you're missing a piece of required initial evidence. There's a list for every single type of application in the instructions for every form of what required initial evidence is. So if you're filing without that required initial evidence, then yes, now they can go straight to a denial. They don't have to send a request for evidence, giving you the opportunity to provide it later on. So those are typically major things that most everybody is going to be providing in their application. So I think there's a possibility where it might expand beyond what's intended. There might be more applications denied where maybe they shouldn't have, but we should be able to get those reopened by explaining the situation or providing the documents. I don't think they're meaning to just flat out deny as many cases as they can. Their goal is to cut out the bare bones petitions that are being filed, just to hold the place until they can get all of the documents together.
Emily, I've gone to a couple of times to Service Center to look into how the Service Center works. And I've looked into applications that they have shown us practically. They have people filing citizenship even when they didn't have any green card at all. There are applications that are completely irrelevant. They file these applications. Green card holders filing for their parents to get the green card. That's not allowed. Only for U.S. citizen parents it's allowed. I am thinking that in those circumstances, instead of USCIS taking a strain of issuing like, well, you don't have a green card and all those things, now I'm expecting a straight denial because they don't have a green card. They're not going to get a citizenship. So I'm not expecting that in H-1B, if somebody didn't provide every document that possibly could exist, I don't think so the denials are coming in that particular thing.
Yeah, I agree.
Emily, on the notice to appear. What is this notice to appear? Is it going to be that the administration is going to issue notice to appear with every denial of the H-1B or change of status, or could it be selective for some of the people who are getting the denial?
Well, it is selective in that there's two things that must occur for an NTA to be issued in employment-based cases. Number one, a denial has to happen, but number two, it has to happen at a time where your I-94 has expired, meaning that you are unlawfully present because of the denial. So this would be a situation where you file a transfer or an extension or a change of status while you're in status before your I-94 expires, and because of long processing times, or maybe there's a request for evidence, the process gets delayed to where it's still pending after your I-94 expires. Now when that happens, you are in a period of authorized stay that allows you to remain in the U.S. Depending on the situation, it may allow you to continue to work, such as an H-1B extension or a transfer. The problem comes in when after your I-94 expires, now you get a denial. In that situation, USCIS now will have the authority to issue a notice to appear, putting you into removal proceedings or deportation proceedings. So it's not going to be just every single denial. It's a denial plus unlawful presence. That is what causes an NTA to be issued. I think a lot of that situation can be avoided by filing early. Don't wait until too close to your I-94 expiration to file your extension or to file a transfer, and file in premium processing so that you get the result before your I-94 expires. We've talked about that for months and months here, just telling people don't wait, don't let it go for 240 days, don't rely on that. And now it's even more important, because if you do wait and your I-94 expires, you get an unexpected denial, you don't really have much choice from that point, and you may end up having to go before an immigration judge. So it mostly can be avoided, but it is something to keep an eye on.
Emily, one thing I'm noticing on this, people not filing premium processing, their employers are telling that if you file premium processing, your chances of denial is very high. I don't think so that is true. I think so when an employer is telling you that the premium processing is going to get you denial, I think so they're lying. I think so they just want you to work for a long period of time and risking your status for their monetary gain. They're not looking into your status when your status is going to expire. If the chances of you getting the denial in premium processing is same as a normal processing. However, if you get a result before your I-94 expires, one is, as Emily said, no chance, most probably you will never get an NTA if that's the case. But also you will have a lot of different options. You can file one more extension, you can file a transfer from company A to company B, you probably can join an end client and then have them file for H-1B. There might be different options that might be there if you get a result. So if an employer is telling you that the premium processing is going to get a denial, I think so he's only looking for his benefit, and I don't think so you should trust that guy.
Yeah, I've gotten that question at least 3 times on the blog today, saying that they were told that premium processing causes denials, and I say it over and over again. Premium processing is not the cause of the denial. The way the case was filed or the strength of the petition is what caused the denial. Premium processing just made it happen faster. But a case is going to get denied in premium or regular the same way. The only difference is you're spending the extra money on it, but it's certainly, in order to save yourself from potential deportation proceedings, that money is well worth it. I don't see any reason not to file in premium processing.
Emily, on this August 9th memo that is coming into effect pretty soon, as we discussed, in April 1st of 1997, approximately 21 years ago when our office was formed, this law went into effect that if you're undocumented present in this country for 180 days, you have a 3-year bar, and if you're undocumented present for 360 days, you have a 10-year bar. It was not that effective for the employment base for most part of it, but this August 9th memo, can you explain what the danger is for the people. And again, the same premium processing is going to come into effect in this one too.
Right, so again, this memo is specifically for F1 students. The reason supposedly why we have this different memo for F1 students versus other types of categories is because the I-94 given to an F1 student is generally duration of status at D/S. That means there's no end date. So there's no point where the person becomes unlawfully present generally, because they're never going to overstay an end date. There is no end date. So now they want to create an end date so that they can start counting unlawful presence. So they're making this clear guidance on when it starts. Now, we had guidance before that said that if a determination is made by USCIS or an immigration judge that you are out of status or an application has been denied, from that date of that decision going forward, you may be considered unlawfully present. Again, this is just pursuant to F1 students. So they start from the day of the decision going forward. That's the current policy. This new policy is going to change that again effective August 9th. It's not the date of the decision, it's the day that they determined a violation of status occurred. So it's possible it could go backwards. It could go backwards a very long period of time, which could then kick in that 3 or 10 year bar. So as an example, let's say that someone who is on their F1 status going to school decides they're going to start working on the side. No OPT, they're going to work without authorization because they want to do that. So say that they've been doing that for 6 months now, and USCIS figures it out in some sort of immigration application. Maybe there was a change of status to H-1B that was filed. The change of status gets denied because USCIS learned of the unauthorized employment. Before August 9th, they would say that from the date of the denial going forward, you're out of status and unlawfully present. After August 9th, they're going to say that from the date of the denial, you're out of status, and from the day you started working without authorization 6 months ago, you are unlawfully present. So before you even get that decision, you've already crossed 180 days, and now when you exit the country to try to come back, you're going to be subject to that 3-year bar. So now in the, I guess, a real world situation, because this memo doesn't take effect until August 9th, the way they set it up was if a decision occurs after August 9th that determines there was a status violation, unlawful presence begins from August 9th. They're not going to go back before August 9th because the memo didn't exist. So that's the one situation where USCIS isn't actually applying things retroactively. So if your decision happens after August 9th, the unlawful presence starts on August 9th. So that is somewhat helpful for those that are have an H-1B pending right now and might be getting a decision sometime after August 9th. At least we know that the unlawful presence won't go back before August 9th. But that's coming into play where premium processing hopefully will be coming back in September.
And please apply premium processing, please.
Yes, please upgrade. If you're in a situation where you are concerned about your F1 status, there may have been a violation. There are some really gray areas right now where we don't really have clear guidance, or we got random clear guidance on a website update, but it doesn't seem to be matching with the actual regulations. So if you're in that situation where you're not quite sure, it would be best to get a result on your H-1B before 180 days from August 9th. So, and last year we had many applications that
denied
were pending.
With the I-94, and then they went to India and got the stamping, and then we might have a big trouble right now.
Right.
If the results come after February 4th of 2019, we might have a big trouble for them coming back. They might be actually permanently banned to come into the United States.
Yeah, so be very careful about that. Don't let your H-1B process go on and on and on. Upgrade it to premium if you're in that kind of situation.
This August 11th memo has significance on two other things which Emily has published on an immigration goal and our in law group, and we have presented two other things that if you club together and read them together, we want the audiences to be very careful though. In this STEM extension, recently the USCIS quietly updated the website without issuing any memo, without modifying any regulations, saying that in the STEM extension, the student cannot work at third-party location because of some limitations that they have to access to that particular location. We have noticed some RFEs on H-1B. We have also had some universities requesting the students to stop working at third-party location. We have also some universities not giving the 983, which allows them to go for the STEM extension if they are working at third-party location. We want you guys to be very careful when an H-1B RFE comes in. There are certain strategies that you might want to implement where when there is a STEM extension third-party placement RFE, the issue has been raised. Before answering, you might want to discuss with your lawyer, do you actually want to address the issue or you want to have a counselor processing request? Because if you do the counselor processing request, they most probably are not going to issue a denial of the change of status. They're going to straightforward issue a counselor processing, so there is no determination that the person has been in unlawful status. So that might be a strategic advantage for you to go for the stamping instead of having to test yourself and be a guinea pig and see what USCIS is going to do. And also, Emily, the issue that pops up is that the day one CPTs, if a person has used the OPT, if the person has used the STEM extension, and we have noticed that some of these people go join in the same master's degree again and get the CPT. Does that has any relationship with the August 11th memo on 180-day rule and 360-day rule?
Yeah, it does, as well as the NTA memo. They all kind of come together. So, we have the interpretation of the F1 visa regulations that states that once you've used your OPT time, or your practical training time, it doesn't specify what type, whether it's OPT or CPT. Once you've used your practical training time, you can't get more practical training unless you go up a degree level. So we have plenty of people where instead of going up a degree level, they go back to school for a second master's degree and are issued I-20s authorizing CPT. Now, USCIS is coming back and saying that I-20 or that CPT is not authorized because you did not go up a degree level. When they issue that determination, they're basically stating that you violated your F1 status by working pursuant to this CPT that was not authorized. With this August 9th memo, now all of a sudden that violation of status becomes unlawful presence from the day the violation began, or August 9th, depending on when the determination occurs. And then we have a denial of a change of status, which is an immigration application, at a time when you're unlawfully present, which means that USCIS will issue an NTA. So all of these things combined can be very risky for students, and you should definitely, if you're in a situation where you use day one CPT, or you're in a situation where you have worked at a third-party site while you're on your STEM OPT, you should, if you get that kind of question raised in your H-1B petition, you should certainly speak with a lawyer to figure out if it may be a better option to convert your change of status to consular processing, avoid that decision, therefore you're avoiding a determination of status violation, avoiding a determination of unlawful presence, avoiding an NTA.
Of course, there is an additional risk of going for stamping, but that's where when you discuss with the lawyer, you will be able to evaluate which one you want to pick though. I want to go to some of the questions. We already answered some of them. Is that Anand is asking the question, if the I-140 has been withdrawn after 180 days of its approval, can I do a further H-1B transfer from company A to company B? I'm assuming that if it's been withdrawn after January 17th of 2017, and if it's been approved for 180 days, if the company withdraws it after January 17th of 2017, and if it's been more than 180 days that the I-140 has been approved, that I-140 stays with you for life. You can transfer to company B with the company A's I-140. You can also transfer from company B to company C. You can transfer to company C to company D with the same I-140 from company A. It will remain with you forever. And for those people who are eligible for H-4 EAD, they can also apply with the withdrawn I-140 of the company A. Assuming that it's been approved for more than 180 days before the company A withdraws, you can do H-4 EAD when the H-4 EAD exists. And it can be used for many different, you can port the date at any point of time. I have had a situation where we have ported the date after 10 years, and they ported the date and it was good. The person got the green card. So you will have that for your life if the I-140 has not been withdrawn.
All right. Right now, with the status of the H-4 EAD, a lot of questions come in about the H-4 person changing to F-1 as a way to study, and then you get work authorization through practical training. Do you think that an H-4 changing status to F-1 is a good option? What are some of the hurdles that they might come across?
Yeah, I see the question. The person got an advice from the DSO saying that please contact the lawyer. Previously, when H-4 to F-1 used to be filed, it used to be adjudicated in 3 months. Nowadays, it's taking approximately anywhere between 9 months to 18 months. I've told a gentleman that when I was filing about 16 months ago, I told that gentleman that, oh, it will be adjudicated in 9 months. Now it's 16 months. Now I'm telling that guy it's 18 months. I don't know the person I'm taking the case, it's 18 months. It might be 24 months or even more. And the problem, there's another problem, Emily, is that they have to maintain their H-4 status until the F-1 is approved, actually 30 days before the F-1 is approved. That's one major step they have a problem with. The other problem they have is that they have to keep on deferring the admission from the university until their F-1 is approved. This is becoming a major hurdle for a lot of people who are trying to convert into H-4 to F-1. Strategically, certain times maybe it is advantage for them to go to India to get the stamping, but then there are issues whether you're going to get the stamping or not. The other thing is maybe if you're eligible for H-4 EAD, why not just apply for H-4 EAD and then you can go to school and work at the same time on H-4 EAD. That's probably an easy solution too. But I think so that if somebody who is wanting to convert into F-1 visa, Emily, I would request them to personally consult with a lawyer to evaluate whether it's a good option for them to do it because of the 18 months delay in the transferring to F-1 visa. There are issues where people have come here on B-1 visa and they change their intention, they want to study here, and it's 18 months they have to maintain the B-1 status. We filed a B1 extension, B2 extension, then we filed a second extension, we filed a third extension, and still their F1 is still not adjudicated. They're going to adjudicate all the B1s and the F1 at one point of time. So since it's taking a long period of time, it's better you personally consult an immigration lawyer before you take a decision of transferring to F1 visa.
All right, question about visa stamping. When do you need to go for stamping? When is it a good time? So a situation where you've just gotten your H-1B extension approved, so you're thinking of going for stamping, but you're also thinking maybe I'm going to transfer to a new employer. Should I go for stamping now? Should I file the transfer and then go for stamping? Which one's better? Well, the initial answer is don't go for stamping. You don't have to go for stamping unless you plan on leaving the country. So if you're
or in some cases where the I-94 is not approved.
Right.
When you have to go.
Yeah, unless you have to go, there's no reason to go for stamping. If you choose to
go, I have to go because my cousin's marriage. I don't think so that's have.
Right.
You can opt for it. Your cousin doesn't want your life to be ruined. And if that's what your cousin want, I think so that's not the wedding you want to go for.
Yeah, I agree. Now is not the best time to go for stamping, regardless of whether it's with a new employer or you just got your extension. We're just seeing more and more 221Gs being issued. That's administrative processing where the consulate is likely looking into the application more detailed, doing security check, background check. Their fraud unit is going behind and contacting different sources to figure out if the information in the petition is valid. So all those things take time. Even if there's, if it's a completely genuine application, there's no issues there, they still take time to go through the process to validate everything. And it could be so many months that you might lose your job while you're waiting.
If you think so that the Trump administration likes the H-1B people, go ahead to the consulate and try your luck there. But if you believe that the Trump administration likes the H-1B people, I guess you need to read Immigration Girl or RN Law Group website closely, and maybe you're not reading the way we want to interpret it to you.
Yeah, going back to what we were talking about with, if you're on F1 status, you filed your change of status to H-1B, maybe if you get one of the RFEs related to CPT or OPT, should you consider converting to consular processing? One area that you really need to consider is if you're in the cap gap. Because once you convert to if you're in the cap gap, once you convert to consular processing, cap gap ends. You're no longer eligible for it. So again, contact your attorney to discuss that, to see if that's a better option to forego the cap gap in order to save the H-1B, or if you want to fight it out and try to win on the H-1B change of status.
Mega has this question: is it safe to file H1 to H4 plus H4 EAD? Absolutely, it is safe to file for H1 to H4 and H4 EAD at the same time. No risk involved. Things are going through very smoothly right now. You can do so. And there's another thing that while on H4, when and if the H4 EAD, they're going to take it off and you cannot file the extension, you can always convert back into H1B without subject to the cap. And Mega, one more tip to you. If you have not applied for the labor and I-140, on H4 EAD, you can still apply for the labor certification I-140. And if by any chance you completed your 6 years of H-1B and now you are on H4 EAD, you can resurrect your H-1B based on the I-140 approval that you got it while you are on H4 EAD.
Also on that, because of the, like we were talking about, the change of status to F1 is taking 18 months. That's the same application that you file a change of status to H4 on. So that is a very long processing time when you're filing the H4 and EAD by itself, meaning separate from the H-1B holder. So because of that long processing time, the EAD won't be approved until they get around to the H4 application. So if you're looking to file a change of status from H1 to H4 plus EAD, the best option is to file it along with your spouse's H-1B, whether it's a transfer, an extension, or maybe an amendment, but file it with the main applicant's H-1B filing so that everything can be processed much faster, especially in premium processing.
Yeah, one major difference between transferring from H1 to H4 compared to the F1 is that when you transfer to F1, you have to maintain the status until you get the F1 approved. But when you apply for the H4, once the H4 start date kicks in, even if it's approved after 12 months or 13 months, you're fine. You don't have to maintain the H1B status.
Right, but you do have to consider that you would have to stop working if you're not going to maintain your H1B
That is right.
status.
Once the H1 expires, you have to stop working. You could also have another plan of going to India and filing, getting the stamping there, but I would recommend that you discuss with a lawyer on that option.
Another question that came up was amendments for H-1B. Are there any problems with getting those approved right now? USCIS already approved the H-1 for me. Now I'm filing an amendment for some, slight change. Do I have something to worry about just because I'm filing an amendment?
Just because you got the H-1B approval, just because you are an H-1B from past 12 years, and now this is the 6th or 7th H-1B that you're filing, and then you're filing an amendment, doesn't mean that it's assumed that your amendment will be approved. It will still be independently judged, your amendment, not just because you got previously approved, it will be independently judged. In this one particular scenario, I might differ in what we have said earlier, Emily. Maybe it's not required to file a premium processing and amendment, Emily. This is a one case because it takes a lot of time. You can always file it again if by any chance you get the denial. Since I-94 is not expiring anywhere soon, it's may not be essential for you to file a premium processing. You can discuss with your lawyer on that, but normally I recommend people you don't need to. However, please note that if you're filing an amendment plus extension and your I-94 is expiring, we would like to get the decision before your I-94. The crucial point here is your I-94 should not expire when you're filing an extension. So when you're filing an amendment, you have enough time. It's okay to file in regular processing, but make sure you get the decision before the I-94 expires.
Nikhil has a good question about what the status of the H-1B lottery petitions is. Is it unusual that you haven't received your approval yet? No, absolutely not. I would expect the majority or a large number of petitions will remain pending into August, September. A lot of them will still be pending October, November, December. I mean, last year we were still getting approvals on March 31st when we were mailing out this year's petitions. So the processing time is very long, which is why we would recommend upgrading to premium processing as soon as it becomes available, especially if you are in the cap gap to where your work authorization expires on September 30th. So if your H-1B is not approved by October 1st, and you're in the cap gap, your cap gap ends, you have to stop working and you cannot work until your H-1B gets approved. So definitely if you're not seeing a result quickly or you get a request for evidence, in order to speed up that processing time and minimize the amount of time where you're stuck not being able to work, you may want to consider upgrading to premium processing.
Emily, you said that they cannot work. Can they stay here after September 30th in the United States after their cap gap is over when their H-1B is pending?
Right. So once you move from September 30th to October 1st, you are in a period of authorized stay based on your pending change of status. So yes, you can remain in the country, but you can't work until your H-1B is approved. One other option to consider is you're in your 60-day grace period after your cap gap ends on September 30th. Starting October 1st, you're into your 60-day grace period. So if you wanted to maintain your F1 status as a backup plan in case your H-1B were to be denied, you could re-enroll in a new program during that 60-day grace period to avoid going out of status in the event of a denial later on.
My I-94 expired on January 2018. However, I got my visa valid till 2019. Should I take any action? Expired on January 2018 and your visa, I don't know how this occurred. It could be that your passport was expiring and then you entered into the United States. They gave only I-94 until 2018. You definitely need to contact a lawyer ASAP. It could be possible that you might be telling that you have an I-94 when you entered into the United States, but now you got another H-1B extension, which the bottom of it has the I-94. If that's the case, you may look to be safe to me there, but if your I-94 has expired and your visa is valid, you are in danger. You need to contact a lawyer immediately. Kawasaki has this question. I am now joining a end client full-time. Is it a good chance for me to get the stamping? Here is, you got a nice job in a nice place. Stay there, work there. Don't risk yourself. Here is what the problem, Mr. Kawasaki, is that when you are going to stamping, they are issuing a 221G. They are telling that it's going to take they are inquiring about your H-1B, which they will take 4 to 6 months sometime, 4 to 6 months for them to get back on you. In that 4 to 6 months, you typically lose a job. If I'm gone in this office for 2 months, my job is gone. That's how the competitive world is here. And then when you go for 5 months and they inquire about it, your job is lost. You yourself will be requesting the consulate to withdraw your application because there is no job for you. You don't want a rejection there. So you will withdraw the application. So that's the circumstances we're seeing a lot of times in the US consulate. We do not recommend. If you have a nice job, just stay here, be good.
Prabhu has a question about visa stamping. He's already with employer 1, has the visa stamp that's valid till September. Now he transferred to employer 2, has that approval, and he's traveling. So he's planning on going for stamping and is asking if something goes wrong with that, can he come back on employer 1's visa stamp? I would suggest, why are you going for stamping at all if you have a valid visa? You can absolutely use the first employer's valid visa stamp along with the second employer's approval notice to travel into the United States. You don't need to go for stamping at all.
Absolutely. As long as you're coming before the expiration of the company's A's passport visa stamping, you don't need to go for stamping, but make sure when you come back, you show the H-1B approval of company B and indicate to the CBP officer that you are not working for the stamped company, but you're working with a different company which has a 797. And make sure you get the I-94 that is valid until the company B's H-1B approval. And if there is any problem, you need to contact a lawyer immediately. But most probably you will be getting an I-94 with the company B's. Now, to answer the other second part of the question, if you're by any chance the company B's H-1B gets, you have the company A's stamping, you still want to go ahead and get the stamping for company B, you get the company B's stamping rejected, you cannot come into this country with company's A stamping. Once your visa is rejected, all your previous visas are invalid. You have to apply for them again.
All right, I think we have time for one more question, and this is one about the STEM extension. So if you are on your OPT and you're working on a third-party site, you filed your STEM extension, the I-765 application. Have we seen any denials of the I-765 due to the third-party location?
Not yet, Emily.
Not yet.
Not yet.
But I do think that there is the potential for that, just based on what we're seeing with the H-1B RFBs. And I do think there's concern there that a denial of a STEM extension could lead to unlawful presence.
Could be.
Because at that point, there's no...
The EAD has already expired and 60-day grace period has already expired. Right. It's definitely a danger. However, I have not noticed it. Please keep watching our videos. We will be presenting every week, and we have a daily conference call. And if you want to make an appointment at any point of time, you can go to rnlawgroup.com, make an appointment with Emily, me, or 13 other lawyers that we have in our office. And like the way that Emily was pointing out, then that is there any STEM extension denials we have seen in the 765 stage when you file for the employment authorization? We have not seen it, but there are a lot of things that are going on. Being in United States right now in the Trump era, you need a constant information if you are on a non-immigrant visa. We would recommend to come every week, and we are going to update the information. Please also go to Immigration Girl Twitter and also immigrationgirl.com. Please go to RN Law Group, and if you want, you can make an appointment at any point of time.
Thanks for joining us today, and as always, stay tuned with us. We'll give you all the information you need.
Thank you.